Hi, everyone. Thank you for joining today's webinar. I'm going to go ahead and give it a couple minutes to get everyone logged in here. I know we just started letting everyone in, so I'm not going to start immediately. Probably wait like about 2 to 3 minutes, but I'll take a look at the attendee list as you guys keep coming in here. But again, thank you so much for joining today's webinar. Seeing a couple more people trickle in, just a heads up, wanted to thank you guys for joining us today, but we're going to wait a couple minutes to give everyone some time from whatever they were doing prior to this webinar. But thank you again for joining. We'll start momentarily. All right, I think we can go ahead and get started because we have a lot of great content to get through today. So I want to make sure we get all of that. So real quickly here, this is just a quick legal disclaimer that we are not a law firm. Everything shared today is for informational purposes only and should not be used as legal advice. So I'm going to give everyone a couple seconds, just check out the legal disclaimer on the page right here. So I'll quickly run through the agenda for what you can expect on today's webinar. First, we'll do an introduction of our speakers. Then we'll get into background screening compliance trends that our compliance experts saw this year and what they mean for your HR teams as we head into 2023. We do have time reserved at the end for Q&A. Thank you to those who submitted questions beforehand. We do have a couple of those. And then also too, if you have any questions that come up, come to mind throughout the webinar today, please go ahead and paste them into the questions box. As you can see on your little panel, put them in the questions box and we'll get them into the Q&A section at the end. So again, we do have time reserved. So if you want to wait until the end, that's fine. If you have it throughout the webinar, please go ahead and post them in the question box. And we did receive some questions prior to the webinar today. If we do not get to your question live, our compliance team will follow up with you after the webinar. And just quickly, as we move in to today's presentation, our compliance team publishes a ton of valuable content throughout the year on Sterling's compliant resources page of our website. So be sure to check that out. Go ahead and look at that. It's on sterlingcheck.com. There's blog posts, an adverse action checklist, other webinars, Sterling Live episode, compliance updates, tools, and so much more. So at any time, you can head over to sterlingcheck.com and visit our compliance resources section. Oops, I went a little too quickly there. Sorry, I want to get some introductions done here. Real quickly, I am your host for today. My name is Caitlin Brower. I'm Sterling's social media manager. But the two individuals that are the most important on today's webinar are Angela Preston and Chris Christian. So I'm going to hand it over to the two of them for them to formally introduce themselves. So Angela, I'll kick it over to you first.
Thanks, Caitlin. And thanks everyone for joining. I'm Angela Preston. For those of you who don't know me, I'm Associate General Counsel here at Sterling. I've spent the last 21 years in the background screening world in some capacity of legal or compliance and ethics. So it's been the focus of my career and my passion. I have had the honor of serving as chair of the Professional Background Screeners Association. I chair the background screening branch of CDIA. So for those of you who are engaged or clients, prospects, friends, colleagues over the years, thanks for joining. And I'll let Chris introduce himself.
Thanks, Angela. Yeah, thank you again for everybody joining. So I'm Chris Christian. I'm one of the directors of compliance here at Sterling. I'll report to Angela. And I've been in the industry for about 17 years and have been with Sterling almost 6 years now. So looking forward to speaking to you today about these topics.
Thank you both. And yep, we do have a lot to go over. So we're actually going to start with a poll question. So you'll see it come up on the screen. We do ask that you all engage with us here. The poll is open. So to get started, so we're just going to get started with this poll question here. So you can go ahead. Have you changed your screening policies in 2022 based on a change to a law or a regulation? It's about 20 seconds or so to answer. So I'm already seeing a ton of answers come in. All right. So we'll take a look at these poll results now. And I am going to hand it over to Angela and Chris just to get, your brief thoughts on these results.
Sure. Yeah, I think that I think we're trying to make the point and forcing you into a box here that the laws are changing. That's the topic today, is really to take a look back at 2022 to see where the laws have changed. If you're not looking at your policies, maybe after this webinar, you might want to take a look. It doesn't mean you need to make a change to your policy, but you need to evaluate it in light of the current landscape, and these things do change, particularly at the state and local level. We are seeing just all the action at the state and in the cities. There's not a whole lot of big major change at the federal level because there are other priorities on the Hill and there's politics on the Hill. So it's important to assess and take this information back, take a look at your policies, meet with your counsel, meet with your internal team, and reevaluate.
All right, Chris, any thoughts on these results?
I suspect that they would be maybe different after the webinar. I think Angela and I probably will present some information that have folks thinking about maybe it's time for a change if they haven't changed already.
All right, well, let's go ahead and get into it. So we are going to start with marijuana laws and federal pardons. Angela, you are going to kick us off here. So I'm going to go ahead and get this over to our first slide.
Great. Okay, so a lot of information to cover here. I just want to start off by reminding everyone that marijuana, cannabis, remains a controlled substance under federal law. So while we have a lot of activity at the state level, states continue to legalize medical use, adult, quote unquote, recreational use, and in some cases simply decriminalize possession. So we have all these different flavors happening at the state and local level. It's impacting the way that employers are looking at testing. I think that, the stats there that I've provided using the National Conference of State Legislators as the source, it's hard to keep up with these things. And we want to cover today some of the laws that changed in the past year, so that just to highlight the recent changes. But looking ahead, just as far as testing considerations, the things that you need to take into account when you take a look at these laws are, whether or not some employers are saying, should we still even test and include marijuana in our panels? The things that you need to consider is whether or not the state or local law provides employment protections for medical use, adult use, recreational use, or both. There are some of these laws that are legalizing recreational or medical use are actually providing protections in the workplace for your employees, saying that it's discriminatory to take action, for example, if you are in a recreational use state. A few of the states I've listed here are states that specifically provide employment protections, either for medical use or even recreational use in those places where it is legal. So off-duty use, there are carve-outs typically for use in the workplace, safety-sensitive positions. There are carve-outs for, where it's required for the employer to be able to be eligible for a federal benefit. There are carve-outs for DOT regulated or other federally regulated or state regulated positions that require drug testing. So it doesn't mean that you can't have a drug-free workplace. It just means that when you're looking at testing, you need to be careful. So you need to look at whether or not the state or local law prohibits pre-employment drug testing. We are seeing that as a new trend. New York City and Philadelphia expressly prohibit pre-employment drug testing. Nevada prohibits taking adverse action. I'm sorry, when I say drug testing, I mean marijuana, cannabis testing. Nevada prohibits taking adverse action for a positive marijuana pre-employment test. And New Jersey also has a provision where you cannot take adverse action solely on a positive test. So the last consideration, of course, and I kind of touched on it on the first bullet, is whether or not the position you're hiring is covered by an exemption. Even if there is some state protection under your state or local law, is there an exemption such as a safety sensitive position or federal DOT or some other federal requirement or state requirement? So those are all the things that you need to be thinking about, Caitlin, if you want to go forward. So some of the new laws of note in 2022, the big one I think that's gotten a lot of the attention is California 2188, the discrimination in employment use of cannabis law. This is an anti-discrimination statute. The enforcement authority is with their civil rights department. So it makes it unlawful to discriminate based on drugs that reveal the presence of non-psychoactive cannabis metabolites in the hair, blood, or urine. It does not apply to building or construction trades. It does not apply if there's a federal mandate or where a test is required under another law. It does allow testing for impairment, and it allows for firing or suspension for possession or use on the job or impairment on the job. The complication and the issue with this statute is the call out that you need to be able to, that you cannot discriminate, or basically what some interpretations of the statute is, unless you can isolate THC, which is the chemical in cannabis that causes impairment, unless you can isolate for that, it casts doubt on your ability to make employment decisions based on the outcome of a test. And as we know, that the testing has not quite caught up with these laws. So the tests that are available on the market, readily available today, don't isolate THC. And so employers are saying, look, if I can't isolate this particular substance, I might be subject of a discrimination claim in using a positive test, even if I had reason to believe that there was an issue, or even if I have a policy in a proper, in a proper carve out. So it makes the testing itself problematic. There is some time to catch up to allow the technology, and I know a lot of our partners are working on very diligently on different testing methods. With an effective date of January 1st, 2024, I think that we're going to see a lot of progress and a lot of focus on the testing, the different aspects of testing. So hopefully by the time this is effective in California, employers will have some additional options in in addition to what they have available today. Rhode Island is the other state where there's a new law this year making adult use or recreational use legal. It does also provide some limited employment protection for employees. Employers cannot take disciplinary action solely for an employee's private lawful use of cannabis outside of the workplace. And again, most of these statutes clearly, identify that it's not okay to use on premises or be under the influence or be impaired on the job. But the challenge there for the employer is how do you test and prove impairment? A lot of training needs to be considered. How are you training your employees to spot impairment, and what are the things that you can do in addition to testing, I think, to beef up your policies and create the structure for what you need to function in the workplace. Maryland also, the voters passed question 4, which was a ballot initiative there that allows for possession of 1.5 ounces, essentially, a decriminalization statute. Missouri, there was a ballot initiative there also that allows for recreational adult use, and it also provides some limited protection for employees for medical use specifically. So I think that in all of these states, some of these laws, you see them passing something that allows adult use, recreational use, and then you see some of the anti-discrimination stuff come later. So we're going to keep our eyes out. But this is some of the highlights of some of the states that have passed new things this past year. Caitlin, oh, there we go. So yeah, I also wanted to touch on one development at the federal level, and that was President Joe Biden's presidential pardon for those Americans who were convicted under a federal law of simple marijuana possession. So in October of this year, he did announce a pardon program where he will be pardoning approximately 6,500 Americans is what the White House estimates. It only applies to federal convictions. So, and it also is limited to simple possession. So anything more complicated than a simple possession conviction is not eligible under this pardon program. And it also applies if the qualifying offense took place on or before October 6th, 2022. So call out on this one, this does not actually seal or expunge a record. So there might be some confusion about that. The court record itself, unless there's additional action that's taken to have the record officially expunged or sealed, the record will remain on the court record. However, the U.S. Attorney General will be issuing certificates of pardon. So presumably what we can see happening is that, an offense or a conviction would still appear on someone's record if you're checking the federal court records, and if that's part of your background screening program. However, you need to think about what you're going to do if your employee comes to you and says, hey, I got this pardon, here's my pardon document. How are you going to manage that particular situation? How are you going to treat offenses? And I think that the idea of behind this presidential pardon is really to get people thinking about how we're looking at these possession charges with the widespread acceptance and legalization at the state level for adult use. And then next slide. Okay, just some quick takeaways. So reminder, again, at the federal level, cannabis remains classified. It's a Schedule I substance under the Controlled Substance Act. Continue to see a proliferation of state laws that allow both medical and recreational use. This has definitely created a headache for employers as to what to do. The trend is really for more of these states to include employment protections. And also the litigation trends that we've seen in this area have really trended towards, in favor of employees and really protecting, for example, the medical use. The trend is really to be more in favor of protecting the employee's right to have activity off duty as is allowed under the state laws. So again, testing, unless there is a state or local prohibition on testing, testing may still be appropriate when you have certain conditions met, reasonable suspicion, impairment, evidence of use at work, following a work-related accident where, where you have a policy or a random program. You can still have a drug-free workplace, even in states or places where there's a prohibition on testing. You just have to mind the protocols for, what exemptions are allowed and when might testing be appropriate, and how are you going to manage that in the context of what's allowed under your state or local rules. Make sure that you're reviewing your policies with your counsel. Be aware of state and local laws where your employees are located. So this is like sort of the post-pandemic world of remote work. We've got people all over the place in different states with remote hiring. You need to keep in mind what law applies to your employee. Where are they working? Where are they, reporting? If they're at home, that, where they reside could very well be the law that applies. So that can be confusing. It makes it hard to have, a standard policy company-wide when you really have employees all over the place. So it's been harder for companies to standardize, which is why some companies are just opting to drop marijuana off the panel. I'm not suggesting that you do that. You may have a need, or your culture may have, an interest in maintaining marijuana testing if you're allowed to do so, but be aware of the specific state or local laws where your employee resides or is working. Again, I mentioned the testing method limitations that where it may not be I'm not a scientist, so I think that we all need to kind of think about, like with alcohol, there is a legal standard for impairment at your state or local level. You've got a legal standard that's typically established how to measure impairment. We don't have that same kind of standard with marijuana. So the tests are getting better. The companies are out there hustling to provide different resources. But keep in mind that a positive test, even with reasonable suspicion or grounds for, suspicion of impairment, a positive test may not be sufficient to protect you from a discrimination claim, like in California with the new law. The other thing I just want to mention is considering oral fluid. Again, I'm not a scientist, and I certainly don't have direct knowledge of the science behind these tests, but we know based on our experience that, and based on the data that we've seen from the different labs, that if you're doing a hair test or a urine test, that the actual chemicals can stay in the hair or the system, the body longer than you would consider for impairment. So some people are moving towards oral fluid as a more timely measure. And again, check with your legal counsel and be sure to do your research on that. But again, some of the states like New Jersey has very strict protocols around testing and making sure that you're using a scientifically proven method for testing.
All right.
All right.
So we're going to move on here to clean slate legislation. So Chris, I'm going to hand it over to you here.
Great. Thank you. So yeah, that was a lot for Angela on that topic. So we're going to jump into something completely different. And there's a lot of information here to cover. So I'll just give a quick kind of caveat. There was a blog that we published earlier this week that kind of dives in a little bit more into Clean Slate. So I just want to put that out there. That was that's on our corporate website. But just kind of jumping into Clean Slate legislation. So I think if you've not heard of this before, if you're not familiar with this terminology, Clean Slate basically refers to legislation as a policy model to provide relief for individuals with criminal record history. Basically, it just provides a way for an individual to have their criminal record expunged or sealed or cleared. You'll see that language in some of these laws from public record systems, essentially the court systems. The primary objectives of these laws are kind of several here, but I'd say the first is really eliminate barriers to employment and access to housing. Another objective is a lot of these are intended to restore civil rights. So, for example, the right to vote, for example, where you might lose that with a criminal record, or right to purchase a weapon, for example. So some of the earlier laws in Clean Slate actually were very focused just on civil rights and have now been expanded, I think, to more employment and to housing access. And then third, it's just simply to provide opportunities for those eligible for criminal record relief after they've already served their time. I think it's important here to note that with Clean Slate laws, these laws have numerous variations. So for example, some provide relief to restore individual civil rights, like we just mentioned. Some establish a petition-based record relief process if the person's records are eligible for that, and petition-based meaning that the person has to go to the court, ask a judge to review it, and pay court fees. Another type of variation of these laws, and this is kind of the more current trend that we're seeing, is that they provide like an automatic criminal record relief, if you will, meaning they don't have to go to the court to petition. Some of these laws provide discrimination protection to job applicants with a criminal history, such as protection if you ask them, do they have a criminal history, they can say, no, I don't, and these laws give them that kind of protection. And then some of these laws have a combination of any of these variations and others. These are just, again, examples. And I think also too, it's kind of important to note that because there's a lot of terminology that gets thrown around out there, these laws do have a crossover relationship with ban the box and fair chance laws. They share a common goal of removing the stigma associated with a criminal record. And so Clean Slate, ban the box, while they're all related, they are different types of legislative initiatives revolving around a larger topic, which is criminal record reform in the United States. Whereas ban the box laws and fair chance laws focus on how and when a criminal history record can be used by an employer. Clean Slate laws actually look to remove the underlying record altogether. Next slide, please. Great. So the trend here that we're seeing, at least based on my research and kind of just looking at this topic, is the legislation is really trending upwards in volume. So this first bullet here, according to the National Conference of State Legislators, from 2019 to 2021, 38 states enacted a total of 179 bills specifically related to topics such as dissemination, discrimination, and consequences of a criminal record. And these bills also contain some version of sealing or purging criminal records by a government agency or a court. As of 2022, October 2022, there were 28 states that allow for some form of automatic criminal record clearing, depending on the type of record offense. So that's quite a bit. And kind of looking over at the third bullet there on the right, the federal government has also joined in on this clean slate movement legislatively, and it has introduced two bills, HR 2864, the Clean Slate Act, and HR 5651, the Fresh Start Act. The Clean Slate Act would require automatic sealing of certain criminal records with individuals with the right to petition the sealing of certain federal arrests and convictions. And the Fresh Start Act would actually authorize the Department of Justice to award grants for states to implement some kind of automatic expungement law. As of this morning, when I checked these laws, these are still pending. I probably don't see them getting passed, but I certainly believe that we will see them recycled in the next federal legislative cycle. Next slide, please. Great. So this is just a very high level list of examples of recent clean slate legislation that's been enacted. And as you can see here, it's geographically all over the board. So you can see that this is the date that was passed, the effective date. Just to note here, this is not a comprehensive list of all states. This is only a sampling. The states that are listed here actually have all have the following common characteristics, which are that all of these have an element of automation of record clearance versus a petition-based method. These have automatic clearance for certain eligibility of a record. They include the clearance of arrest-only records. They include misdemeanor records, certain misdemeanor records for clearing, and they also include, at least one felony record for clearing. So, and as you can see, the effective dates on the right, I just kind of want to point out, and I'll talk about this in another slide, but some of these laws take time to kind of implement. So if you're kind of looking at these and thinking, well, the effective date, it's a long time away from it, what we're seeing is that some of these states they're having a hard time kind of getting these things implemented because clearing records out of statewide repositories and even court records, court level records, it takes some time.
Yeah, and just to chime in there to state the obvious, I mean, this is a tremendous lift for clerks, and the courts at the county level are under tremendous pressure and constraints, and this creates another thing for them to implement. So whether that, some courts are probably more technologically prepared to deal with this sort of a mandate, but there's funding and budget issues around these requirements. How are they going to actually staff or fund the technology that's required to do this? How, just getting the requirements around it. So it's going to take some time for these things to be rolled out. And of course, also stating the obvious, things that you would typically be used to having in your background screening report will no longer be available and no longer accessible for employers. So.
Yep, exactly. Just to add on to that, I know Michigan is, the rumor is that Michigan is potentially having to take even more time right now. They've passed their law, as you can see, but they're having a hard time trying to get this done. So there's potential push out. So that's just another example of that. Okay, next slide, please. Yep. So yeah, so just some takeaways here. So I think legislatively speaking, I think this movement is still relatively young. It's very complex because these laws all look very different. While they still have a common theme, they're different. and it gets complex, and they continue to evolve. The legislation has changed over each year, and iterations of these laws are changing. So to know exactly what the future impacts are on employers is not very clear. We can speculate, and we can probably see, certainly speak about more than likely if you're doing background screening, you're gonna eventually come across a candidate who has a criminal history and is subject to one of these laws. And so you're going to have to figure out how to deal with that from your policies and procedures in your screening program. Next bullet here, I think should always be looking to monitor federal, state, and local legislation around Clean Slate and Ban the Box and Fair Chance, because those laws are still continuing to come out today. And essentially what you're trying to do is identify the laws that may impact your program, especially given the complexity of remote work today and applicability of laws in the jurisdictions. Regularly review and update your background screening program goals, policies, and procedures so that you can adjust to new legislation that comes out. We've talked a little bit about that in the poll question. Consider modifications to your policies and practices for inquiring about criminal history, where the law actually allows the applicant to state they don't have one. So if you're asking those kinds of questions about an applicant's criminal history, you might want to make sure that you're not doing that in one of these jurisdictions that has protection for these individuals. And then last, consider reviewing your policies and procedures with legal counsel as always, and before you make any changes to your policies.
All right.
I think, I think that's for that one.
Yep.
I just want to make a note on Chris's takeaways here, because I want to make a point of just calling it out. The Clean Slate laws, and again, I think I don't want to assume that this is obvious, but the Clean Slate laws, the idea is that it's as if this person does not have a record. It's to wipe the record clean in many cases, just facilitating that, making that process easier, automating it, making it, sort of without even having to request or file anything, making it automated at the court level. So it doesn't mean that you still don't have to consider things around like Ban the Box or fair chance laws that require individualized review of the criminal history. So it all sort of ties together to say, look, some things we believe should be wiped clean because the level of offense or after a certain period of time. Other things we think require really thoughtful consideration as to the applicability to the job. So it really puts the burden on the employer to put the program together in a thoughtful way that takes into account these state, local, or federal EEO guideline requirements around individualized assessment and the timing of when you ask about criminal history and what type of searches you want to do on your background check, what is your, what's your program. So it really is incumbent upon like the employers to take a look at all of this stuff and say, okay, what do I really need for my organization? What do I really need for my culture, for the positions for which I'm hiring, safety sensitive, non-safety sensitive? What's our position as a culture around second chance hiring, fair chance hiring? What kind of organization do we want to be? It all plays into, these laws are creating a real patchwork. So looking at it from a policy perspective is really key.
All right. So we do have a second poll question for our audience. So we're going to go ahead and launch this poll now. So how does your organization track new background screening laws and regulations? And you've got 3 options there. So leave it up for a little bit, about like 20 seconds or so. All right, seeing the numbers come in, just gonna wait a little bit longer. All right. All right, so we've got our numbers here. So Angela and Chris, curious to, your thoughts on these results.
I'm glad to see the numbers around, what you're doing in-house with your internal staff and your in-house legal departments. That's great. Of course, we're doing this webinar today because we know that a lot of you rely on outside expertise, and hopefully with our, this is our business, this is what we do. So hopefully we're able to provide you with that additional resource and that content today. So yeah, I think I'm encouraged by these.
Chris, any thoughts?
Yeah, I think for internal staff, the percentage there, I think that's surprisingly high. It's difficult to track these things, and it's kind of part of my job, and it gets overwhelming. So yeah, hats off to the internal folks who do that. I'm right there with you.
I suppose that this webinar sort of is biased towards that outcome, since if the internal staff is tracking and monitoring, they're attending webinars and they're doing the right things to stay educated. So that's great. Let's move on.
All right. So we are moving into new and noteworthy legislation in California and elsewhere. So Angela, I'm going to hand it back over to you.
Okay, yeah, so we just wanted to sort of do a quick hit list here of some of the noteworthy laws. We always single out California because California is special, and we appreciate that about California. So in case you missed it, there was California AB 506, which actually went into effect in January of this year, which requires background checks for volunteers, employees, and administrators of organizations that provide youth services. So I just wanted to touch on that because that was almost a year ago now, in January of this year. Can't believe it's December 1st, by the way. California Senate Bill 1162, pay disclosure and pay reporting law. I'm going to touch on that a little bit more in the next slide, but this is one that's getting a lot of attention, and the whole trend around pay disclosure, pay equity laws. And California jumped right into the fray with 1162. Then we have California Senate Bill 731, which requires sealing of felony records or non-sex offender related non-violent offenses that meet certain criteria, which I've listed there, certain timeframes, and where the sentence, the parole or probation or sentence was completed as directed. So again, this is clean slate. This is exactly what Chris has been talking about. There is a real push to for that movement in California, certainly. And actually, it did start with cannabis reform, and the next one, California AB 1706, was really enacted to put some timelines and some mandates around a prior law that had required courts to seal records for certain types of eligible cannabis convictions. It wasn't happening fast enough. It wasn't happening according to the legislature's liking, and so courts now have until March 1st, 2023 to seal records for those qualifying cannabis-related offenses. California Senate Bill 1262 is one that did not pass. It passed the legislature, but it ended up being vetoed by the governor. We're calling it out today because this is the bill that would have required date of birth and driver's license information to be available in the public record, which for those of you who are doing background screening, you should know that we require or really rely on those identifiers, date of birth, and in some cases a driver's license number, to positively identify that the record at the court matches your subject. And without those identifiers, we are challenged in much slower turnaround times, the need to do a lot of manual going to the court directly. It's causing a huge burden. There was a court decision in California that sort of launched the courts on this path of removing identifiers from the court record. And this bill was a response to that, which made it all the way through the legislature. The legislators recognized that this was a necessary and good thing, but the governor had concerns, and there was some pushback. So we are continuing to fight for identifiers in the public record, and we have been working with our trade associations, CDIA, PBSA, on plans to continue to get full access to those identifiers in the future. And we do appreciate everyone's support on that effort. So I did want to call that out today. Next slide. Okay, so some other states, it's not just California. Mississippi enacted a pay equity law, and most of the trends that we're highlighting here today have to do with background screening and employment issues around your hiring and your onboarding. And so pay equity and pay disclosure laws are sort of the big trend here. And Chris already hit on some of the other categories. So Mississippi did enact an equal pay law, which prohibits pay discrimination based on sex. It doesn't get into the banning of salary history that we've seen in other states. It's sort of a very high level measure in Mississippi. However, it is a step in that direction of requiring that there is equality. So definitely a step forward there. New York City and Westchester County I'm calling those out, where there is a pay disclosure requirement now. Employers with 4 or more employees have to publish minimum and maximum base pay or hourly pay that is expected for the job position. It has to be posted. It has to be provided to current employees. So this is another trend where it's just all around your hiring process. You need to think about if you're hiring people remotely, does the law apply to them? If the employer is based elsewhere, but the employee is being recruited in New York City, then you need to think about compliance with these laws. Rhode Island, effective January of next year, pay range disclosure law also, along with the salary history ban. This applies, again, both to applicants and employees, and you have to provide the pay range prior to discussions around compensation. Washington, a pay range disclosure law for employers with 15 or more employees. You must disclose the wage scale and salary range, and also provide a general description of benefits. And then California Senate Bill 1162, as I mentioned on the prior slide, employers will be required to disclose pay scales to current employees on job postings. And there's also a reporting requirement element to this, which kind of gets into more specific HR compliance, but essentially having to report their stats and their data to the California Civil Rights Department that will be monitoring and tracking and auditing this enforcement of this law. So that's the roundup.
All right, so we're going to move into our last section. I am, checking out time here. We have about 10 minutes left. So Chris, I'm going to ask you to run through these, not super speedy. I want to get to a couple of audience questions, but a gentle reminder, if we don't get to your question, we did get a couple live in too. We will follow up and get them answered after the webinar. So Chris, handing it over here for legislative trends, AI, and automated employment tools.
Sure, yeah, and there is a blog on this back in April, so if we don't get through all this, and we'll go through this quickly, you can read on that blog, and it kind of dives into some of this topic a little further. But just kind of looking at this, we'll just talk really quick about the contributing factors to the legislative trends that we're going to talk about here. So one is what's behind employers' use of AI and automated employment tools. It's really kind of two things from what we're seeing. Trying to avoid discrimination and bias in the hiring decision that kind of is sometimes obviously built in with human decisions. And then second, the use of these tools improves efficiency in the hiring process and the onboarding process. I think another factor here is the use of AI and automated employment tools has gained attention both at the federal and the state level, and so lawmakers are paying attention. And as you'll see here in the other slides, they're starting to make legislative efforts in those areas. Lawmakers' concerns of built-in discrimination and bias unintentionally rooted in these hiring tools is another issue why it's getting attention. Potentially, these tools are doing what employers are trying to avoid, which is having bias and discriminating. But these tools somehow are unintentionally doing it. But the way that the algorithms are built, those bias and discrimination elements exist. And then last, I think this is really, I think, important here is that the federal level focus on AI and algorithm automation impacts on discrimination and bias in employment context. There's been a lot of activity from the federal government, so we'll talk about that here next. So yeah, next slide. So this is a very fringe topic, and it's very interesting to me, and I'm curious to see how this will evolve over time. But I don't think we can talk about it without at least trying to cover what these terms mean. And I guess I'll just summarize this slide by saying the point that I'm trying to call out here and bring to people's attention is that the definitions of artificial intelligence, as you can see on the left here, in doing some research, I was not able to find a single agreed upon a definition. You can see Webster's Webster Dictionary definition. This is Congress's definition, which, by the way, comes from the National Artificial Intelligence Initiative Act of 2020. So that actually was carved out of of federal legislation. And then third, Cambridge Dictionary version. So as you can see, these terms are very broad. These definitions are very broad, use very vague terms, and they're not consistent. And the challenge with that is that when policymakers start making laws and using different variations of definitions, it makes compliance to these laws difficult and confusing. And so then guidance is needed and insight from regulators as to what they expect and what these things mean. On the right-hand side, you'll see here definitions from New York City and California of what essentially these two laws call automated employment tools or automated employment decision tools. So I'm not going to read these definitions to you, but they have the same element. They're very vague, very broad. And when you read it, it's not crystal clear as to what these things actually mean. So yeah, I just kind of wanted to point out that these are definitions, and as you can see, they're not the same. Next slide. So over the past several years, there's been various federal agencies that have shown interest in this particular topic. This is just a quick, brief overview of some of that activity. There's much more out there. If you Google federal government AI, you will find tons of information, but just kind of run through some of these here. So the Department of Commerce in April of 2022, they appointed 27 members to the National AI Advisory Committee. If you're wondering what that committee does and is, it is a committee that advises the President of the United States, and also the National AI Initiative Office. So there's actually a federal government office now overseeing AI. The White House in October of 2022 released what it calls its blueprint for an AI Bill of Rights. Essentially, that Bill of Rights has 5 principles around the design, use, and deployment of automated systems and algorithms. One of those principles is called the Algorithmic Discrimination Protections, which can be tied directly to employment decisions and discrimination in employment decisions that use these tools. Next, the Federal Trade Commission. I'd say they've been the most active of all the federal agencies. As you can see here, they have issued numerous reports throughout the years. I would encourage you to look at these. It will give you an idea of how the Federal Trade Commission views the use of AI and automated tools and the problems that they see potentially with employers using them, and automatically making these tools automatically making a final decision without some kind of more of a human review. The EEOC and Department of Justice in May of 2022, they issued guidance on Americans with Disability Act and the use of AI to assess job applicants and employees. And then last, we've actually seen some federal legislation come out or proposed around this topic, HR 6590 and S 3572, Algorithmic Accountability Act of 2022. This would essentially direct the Federal Trade Commission to conduct or require impact assessments of automated systems and augmented critical decision processes, or algorithms is another term that's used for that. Currently, neither one of these have passed, but to paint a picture, the federal government here is very active and very much paying attention. Next slide. So at the state level, we're seeing activity as well. Not as much, but I think we're going to in 2023 for sure. So obviously New York City and California, as you can see here. So in 2021, New York City passed local law 1894A, which becomes effective January 1st of 2023, by the way, so just around the corner. So that law is a new law that makes it unlawful for an employer or an employment agency to use automated decision tools to screen a candidate, unless that tool has been gone through a bias audit. The audit is made public off of the employer's website to the public, the results of that audit, and then also the employer notifies the candidate that these tools will be used to assess them and what skills and what particular job requirements are these tools being used. October of 2022, the New York City Commission on Human Rights has proposed rules that would help clarify some of the ambiguities under this law. Those rules have not been adopted yet. We've been keeping a close eye on them. They have been open to public comment, but so far as of this morning, I couldn't find that those laws have been adopted yet. But those rules are going to supposedly help clarify some of the confusing elements of that law. California also has proposed draft revisions titled Employment Regulations regarding automated decision systems. And essentially this would expand the state's existing discrimination and employment law, and it would expand liability risks of employers and their vendors that use, sell, or administer employment screening tools that leverage AI. Those rules have not yet either been adopted, so keeping a close eye on them. Other state activity, Colorado, Illinois, Vermont, Washington, they've created a task force to study AI. And then as you can see here, the last bullet, this is just some statistics on volume. So over 2020, 2021, and 2022, we've seen states pass bills. I expect to see more bills at the end of 2023. And then last slide. So just takeaways here. Monitoring legislation on this topic. I think the second bullet here is the most important. These definitions, like I talked about, are vague and broad. So, if you're not clear on them, have legal counsel help you with those assessments. Review your procedures in light of AI and automation, and always consult legal counsel before making any changes. So, sorry, Caitlin, I almost pulled it off.
Almost. So with that, I'm going to go ahead and conclude today's webinar. I want to be respectful of everyone's time. We did again get a handful of questions in prior to today's webinar, and we got a ton live. So Chris and Angela are actually going to follow up on all of these questions, so you will get answers. We are very, very thankful of how engaged you guys were throughout the webinar today. So we really hope you found this valuable. You're going to receive a quick 3-question survey once this closes out. So we really, really appreciate your feedback. You're going to get an email too in the next couple of days with the recording and detail on SHRM and HRCI credits. Be on the lookout in January of 2023. We are not done talking about these trends. I'm going to be hosting a Sterling Live session with Angela and Chris, and we'll go over the main topics from today. So be on the lookout for that. And then at any time, you can go ahead and go to our compliance hub. This link is going to be in the chat right now on GoToWebinar for more content and information. And you can also sign up for our newsletter for the Compliance Hub, so you can get content, get information directly to you every quarter in regards to compliance. So thank you all again for joining us today. We hope to see you on our next compliance webinar, and I'm wishing you all a happy holiday season. Thank you again.
Thanks, everyone.